Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber. I'm going to be with you for the next 3 hours as we take a deep dive into the double murder trial of rapper YNW Melly. Now, this defendant, whose birth name is Jamell Demons, faces 2 counts of first-degree murder in the deaths of his 2 friends, Anthony Williams and Christopher Thomas Jr. The victims, who went by the names YNW Sakchaser and YNW Juvy, were both aspiring rappers themselves. The Murder on My Mind rapper and his co-defendant Cortlen Henry were in the car with the 2 victims when they claimed that a drive-by shooting occurred. But for them, unfortunately, evidence later suggested that the gunshots took place from inside the vehicle, and this was a staged drive-by shooting. Day 6 is slated to start up any minute now. I'm going to keep a very careful eye on that courtroom feed. But as we wait, I want to go back to something that happened yesterday. So we heard a lot of forensic cell phone evidence yesterday, but at one point there were arguments over certain data that the defense didn't find permissible. So to kind of get you a better idea of what that was all about, let's take a little listen about the arguments from yesterday.
Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sakchaser Howard. Sakchaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamell Demons. It was retrieved from Jameson Francois, not Jamell Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter of all the information they're seeking to put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence. And that's why we objected before.
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
Okay, let's break this down a little bit. I'm joined right now by law enforcement instructor Sonny Slaughter, along with criminal defense attorney and civil rights attorney Tyler Bailey. Great lineup. Look at my guest this morning. Fantastic. It's great to have you both here. Sonny, I'm going to start with you because here's the big takeaway from yesterday, in my opinion, right? Is that you didn't really hear anything about what this cell phone contents were, or even if it's directly tied to YNW Melly. It seems to me that there is a cell phone that could have been used by him, but might have been circulated by multiple people. Do you get the same sense there?
And that's exactly what I was thinking. I was wondering, is this like a community phone? What relevance does it have to the particular incident? Is there some information that the prosecution can tie directly to this incident that says that these individuals committed this crime, or there was some kind of conversation, and because the cell phone was used and the data that that the defense is talking about has to do with information that happened after he was arrested and incarcerated, even though he had the PIN number to open the phone. It's all questionable and speculative when you look at what they're asking for and what they're trying to do with it. I think we need to stay closer to the date of the incident, what happened, and if there's anything that they can tie to this particular crime being planned out specifically.
Yeah, Tyler, let me throw it to you, right? So as we were just saying, the state wants to use this cell phone data from a phone that was still in use after the defendant was arrested. Doesn't make sense. Is it his or not? I mean, that seems like a pretty good basis for an argument from the defense, who, by the way, has been of the opinion that this investigation was botched and that law enforcement had tunnel vision and only focused on YNW Melly because he's famous. What's your take on it?
Well, first, addressing the issue with the cell phone, I mean, the stakes are very high for the defense here. YNW Melly's life is technically on the line. I think the state, considering the death penalty, at the bare minimum, he would do life in jail. So to admit this cell phone evidence when there's a lot of fingers pointing to others using this phone, even when he was in jail, although he has a PIN number, I think the stakes are really too high for them to allow the cell phone evidence when it's highly prejudicial to Melly, and there's a lot of evidence pointing to others using the phone. In addition, you know, defense lawyers, you have to zone in on biased law enforcement. When you're somebody like a star, like the defendant is here, it makes sense to paint a picture that the state has zeroed in on him for the jump, that he is guilty, listen to his songs and look at his demeanor. I think the state is kind of leaning on those things, but this evidence for the cell phone is really too unreliable, highly prejudicial, and hopefully the judge does the right thing. But if not, this is definitely an issue for appeal.
Well, let's talk about what the judge
they'll
did.
use in the future.
Yeah, and let's talk about what the judge did. The judge ultimately denied the defense's motion to leave this data out, but let's listen to his reasoning.
My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's not the methodology is and basically a Daubert issue on it. It's not clear. It's not been established. All those types of things that should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z. There, you're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial and probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying it's something more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it.
All right, Sonny, I'll start with you. You agree with the judge?
Yes, I do. I think until they can connect the dots, this case is really about connecting the dots and not being all over the place. This is the reason why law enforcement investigative processes, along with the prosecution team, really matter. Making sure that they're not flying all over the place and that they have a straight line through with a conversation and a narrative that not only makes sense, but that is full of investigative and probative value to the jury, because that's what the jury is going to be looking at. What makes sense, what matters, and did they tie everything together? And in this particular incident, I don't think they have.
All right, going to turn over to you, Tyler. What do you think?
Well, I think the judge made a fair call. He noted the objection. The defense made their argument. At the end of the day, I think it gives the defense something to argue on appeal. Things don't go well for them at the trial court level if he's found guilty. I understand the judge's reasoning, saying that he does not necessarily know what's on the cell phone. At this point, they're just trying to keep the cell phone evidence out altogether. I'm sure they'll raise an objection when this evidence is offered to the jury, and they'll preserve it for the record.
Yeah, that's a big point, because we talked about it yesterday, too, how the defense lost their motion for a mistrial when it came to the testimony of Felicia Holmes, who was the defendant's ex-girlfriend's mother, and some questionable testimony that came in that the jury heard. The defense said that this was improper. The jury shouldn't have heard this. The judge denied that motion for a mistrial. But again, if their client is ultimately convicted on appeal, they can raise that issue. That is preserved on the record. Let's take a break. When we come back, we're waiting to jump live in this courtroom for a continuation of the YNW Melly trial. Stay with us. everybody. Thanks for coming back to our coverage of the YNW Melly double murder trial here on Law and Crime. Today is going to be day 6 of the trial against Jamell Demons, who faces 2 counts of first-degree murder in the shooting deaths of his 2 friends. Proceedings should be starting up any minute now. I'm keeping a careful eye on that courtroom feed. But in the meantime, we're going to go to the Broward County Courthouse because we have a very special guest. We want to introduce our boots on the ground, who is right outside of that courthouse, Law and Crime's very own Terry Austin. Good morning, Terry. Actually, I don't know if you're inside or outside the courthouse right now, but what's the atmosphere like?
Well, today we are inside the courthouse, right down from the courtroom, and it is really a little bit quiet right now. They haven't started up. I did see the witness from yesterday. That's FBI Special Agent Brendan Collins. He got on the stand yesterday. He's from the CAST unit, which stands for the Cellular Analysis Survey Team, and he just talked about his background information. He's going to get back up on that stand today. I will tell you that yesterday it was fairly intense. The jury was paying very close attention to these forensic analysis experts. Although they did not do much analysis, they did mostly just the collection and extraction. So we'll see what happens today with the FBI agent.
That's a little surprising to me. I thought that when you hear this kind of data, the jury might zone out a little bit, but it's good to hear that they're paying attention to it, because if you talk about yesterday, we talked about this before, excuse me, we heard a lot of the cell phone data evidence, and at one point the defense argued that that certain data shouldn't be permitted into evidence because one of the reasons was that multiple people had access to the iPhone even after the defendant, Mr. Demons, was incarcerated. What can you tell us about that?
Well, I know that there were 2 experts who were on the stand. Susan Johnson, she extracted the cellular data, and I do think that the defense was objecting because there were people who had custody and control of those cell phones, and it wasn't easy to authenticate that information. Plus the fact that she didn't analyze it at all, and on cross-examination, we did hear her say all she did was collect the data. And the exact same thing happened, Jesse, to the second witness who collected information. He collected that health data, and the objection from the defense as far as that was concerned is this information is not trustworthy.
We all ready to proceed?
If we could just approach briefly, Your Honor, I'd like to bring things to the court's attention.
I'll double check. I don't think
So I don't think counsel was suspicious that the attorneys had anything to do with that. I don't know if that was usually asking me to do it, so I appreciate it. I certainly will. And Sigmund Garrett, do you have anything you need? Can you make sure the school is concerned about some of the correct? I'll call the sergeant now.
she finishes her direct, if we could
I can't hear you, sorry.
Sorry. If after she finishes the direct, if we could have a brief break so I can set up with the computer. All right, perfect. Thanks, Judge.
When Ms. Durrett, AOC comes back, there's just one issue I want to raise.
I'm sorry.
May we approach very briefly? Come on, Pastor. There's nothing. I asked the officers to start coming and just sit. And I need to go outside and find that good.
You want to bring something up, Mr. Hart?
Yes, Your Honor. It needed to be sidebar, but the state just advised. If the court recalls yesterday, I was inquiring with the witness whether or not he, Miramar Police Department had any other software to test the results of their Celebrite download on. He said no, wasn't done. The state advised me half an hour ago that there was another one done on another software in June of this year, which the state did not disclose, purportedly because we asked for discovery to be closed, even though the state opposed the closing of the discovery and the court denied closing discovery. Nonetheless, the state indicates that it failed to meet that discovery obligation because we were asking to close discovery, but wants now to introduce through another witness the fact that another analysis was done in June of this year. And we would object to that admission based upon the discovery violation and the ambush that would ensue.
So you're alleging there's a discovery violation, so when you allege that, I need to do Richardson here and just find out whether what you're saying is true and not true, and whether it's inadvertent or intentional, and make some decisions. You heard what the counsel suggested, so what are you telling me?
So, Your Honor, in terms of there was an additional evaluation that was done, this was done, and the only reason why it's even coming up is because of counsel's questioning. So based on counsel's questioning and asking if there was additional or other ways to prove it, a different witness, Detective Moretti, did a second analysis of the cell phone. Because at the time when Detective Zeller had it and did this, they did not have an additional software program called Breaky. Miramar Police has then subsequently obtained the license for Breaky. So the state's position is that based on questioning by defense, the state then would instruct the witness to go and do an additional download of the phone on that. So that was done in June of 2023. On that, the phone and everything is the same, and the only difference is there's additional location data that is on the new download that was not on the prior download. So there's any more information on that. None of that is exculpatory. We're just going to say that the defendant was not at the scene of the homicide and not there on that. The state doesn't have it in their possession yet. My understanding is it will be dropped off later this afternoon.
So is it fair to say then that defense requested whatever downloads there were, and a download, the Celebrite download, was turned over to them?
Yes.
The first one?
Yes.
But there had been a second download done, and that download was not sent to them?
It's not yet even been turned over to the state. I'm waiting for it from the detective. He's going to be bringing it later this afternoon.
Okay, and when did this second happen?
That would have been about a week or 2 weeks ago. I'd have to double check on the date. I haven't seen it for the exact time.
So subsequent to the trial starting, you still were having downloads done?
In terms of if there was any other information, anything that was exculpatory, then I'd have to make sure that that was fully explored and turn that over to defense.
And so that it has been turned over to them, so the defense doesn't know anything about it. Mm-hmm. And then defense counsel asks questions about other possible programs that they might have had, because he doesn't know if there are any or not. And the witness, Zeller,
yes.
Answers that they don't have it. And so something that he doesn't know, that prior to his testifying, you've already run a second program through a different detective already on a different system.
Yes, so the defense didn't depose Detective Zeller because then they could have asked questions such as, does Miramar now have additional software that this could be done on? So they chose not to do so on that.
The question comes back to is when this second download was done on different software, that was just 2 weeks ago.
Yes.
When did you found out about it?
I still don't have a copy of it. I was talking with the detective last night on it in terms of the download being done. I have to look and see exactly on the date and if it was being communicated to me about the results.
Who asked for the download to be done?
It was discussed with the detective in the pre-trials as to if there was any other information, if there was any updates to the Celebrate program, as Detective Zeller testified to, that sometimes downloads are redone once there is updates to the software.
So this is new information that Detective Zeller doesn't know about.
Correct.
And Detective Moretti hasn't been told about.
Correct.
And it's something that's new to you that you just came up with in your pre-trial. How long ago was that?
I have to look on the exact date on when that was.
Yeah, tell me what
sometime
the
the week, I believe, of May 21st or 23rd, sometime at that, during the course of that week. As to when the actual analysis was done, I couldn't tell you right now because I don't have it yet. But this is analogous to, for example, if defense were to cross-examine a witness about evidence that was tested or not tested. If they open that door, then the state would be able to go forth and send additional items for testing on that.
And to your knowledge, there's no cutoff on this script.
Correct.
Thank you. Anything else?
Yes, Your Honor. There were two questions that the court just asked the state, which I noticed were not answered. The first was, who asked for it to be done? The second was, when did you, Ms. Bradley, find out that it was done? Neither question was directly answered. Both answers were evasive. If I asked a question that precipitated the state going and doing further investigation, one, we again keep arguing that that is an ambush that affects the fairness of the trial, and that's why there needs to be a discovery cutoff. But also, that's not what occurred here. The state's discovery obligation is triggered by the rules, not by questions I put to a witness during trial. So if the state was aware of the existence of the fact that another download was done, whether the report was not, and that we are in trial, and then puts a witness on the stand to say, well, we're going to turn it over to you now because you asked a question, I don't think is a good faith response. One, we need a discovery cutoff, and we need one to be put in place now so that this propensity for ambush is not enabled. Also, That's not the case in this instance. There was an analysis done. Ms. Bradley knew about it. She knew of her obligation to turn it over. She didn't turn over the fact that it was done, nor did she turn over the report. Apparently the report she is now claiming has not yet been finalized. If the analysis was done, it's a download. If the download was done, then the material from that download exists. This isn't a test that's done. It's a download. So if this download was done a few weeks ago, that is the material that should be turned over. And it was not. And we would object to any reference to it. And the defense team is going to discuss what other, we'd also for the court to inquire the state if there's any other discovery out there about which they know to exist and have not turned over. And we're going to discuss whether or not we're going to seek any further relief. But we would ask that the state be prohibited from engaging in this ambush. They've had it for over a month now?
No, of course. So I think I have to look at the notes on that and answer on, so if Your Honor wants me to respond on those, I can go and check exact dates on emails.
That's fine. You can check the dates and that type of thing. Right now, I'm deferring ruling on it. Detective Moretti's not anticipated to testify today, is he?
No.
So we'll talk about that later in the day.
Sure.
Okay?
Your Honor, we also move for a discovery.
Understood. I heard it. I defer ruling on it. All right.
Thanks.
Let's bring the jury in, please.
If we could have the witness resume his seat.
Sure.
Are there any people?
You bring the jury in.
There's no family.
They'll take care of it.
Jury entering.
Ladies and gentlemen, thank you. Please be seated. The record once again reflects the presence of the defendant, Mr. Demons, and the counsel, the assistant state attorney, ladies and gentlemen of the jury. Our witness, Special Agent Collins, will witness on the stand. Good morning, sir. Please have a seat. Just want to remind you, you remain under oath. Agent Collins. Ladies and gentlemen, I did get a question, and I was just discussing with the attorneys regarding the scheduling, and my understanding from speaking with the attorney is that they anticipate the trial would conclude before the end of July. Trial is a fluid process. You don't always know exactly what the next witness is or who the witness is going to be. Can you hear me?
So how are they working?
I apologize. So let me start over. I received a question about when the schedule of the trial, what the it's anticipated to conclude. I spoke with the attorneys. They advised me they believe the trial would be over before the end of July. I want to remind you also that because the attorneys reminded me, I forgot that there's the week of July 3rd, 4th, 5th, 6th, and 7th. That week we're not going to be in session. It's we'll finish out the end of June and then pick it up again on July 10th. The week commencing Monday, July 3rd, we're not going to be in session. But the attorneys think the trial will conclude by the end of June. All right? So, ladies and gentlemen, when we were last here, Special Agent Collins was on the stand as a witness. He remains under oath. And counsel, you want to finish with your direct examination?
Yes, Your Honor, if I may.
You may.
Okay, Detective Collins, we had just discussed about your training and experience, and remind the ladies and gentlemen of the jury, in what field do you work?
I'm testifying here today in my role as a CAST asset, so cellular analysis survey team, a group that specializes in historic cell site analysis and device location analysis.
And have you used historical records to locate fugitives and missing persons before?
Yes.
Did you conduct historical cell site analysis in this case?
Yes.
Okay. Did you prepare demonstratives to help show and explain to the ladies and gentlemen of the jury what your analysis is and how it is completed?
Yes.
Okay. I want to start with and go over the cell site records. Are those records provided to you?
Yes.
Okay. And so what's been previously admitted into evidence as states 63 and 64. Thank you. Starting with state 63. I'm going to open up some of the records, and if you would be so kind to follow along. So starting with what is in state 63, going to the tracking number 2058127. And so it's clear. When I also publish state 28. This phone number 772-713-9807. Is that one of the phone records that you analyzed in this case?
Yes.
Okay. And states 28 is a pawn slip. Have you ever seen that one before?
No, I haven't.
So going back to the same phone number, 772-713-9807. Can you explain to the ladies and gentlemen of the jury what we're looking at in these phone records?
Sure. So this is a report from T-Mobile. It's an engineering report, and you may also hear it as referred to as a TrueCaller quantum data or timing advanced data. But essentially what this is it's records of, from the network's perspective, location where the phone likely was during particular times. So you'll see a series of columns on here. At the top it explains what is contained in each column, and then you'll have a series of entries. All that is associated with a particular time. So column A in this case is end latitude, and column B is ending longitude. It says what the confidence level is, the IMSI, column E, and the INDI. Those are numbers that are assigned to the device. So the IMSI is sort of like your SIM card. It's a subscriber number that authenticates on the network, so that when you have a cell phone communicating with the network knows that your customer is paid and they can give you network resources. The INDI is about the device that you have in your hand.
It's been a little while since geography, so could you please explain what latitude and longitude are?
Yeah, those are coordinates on the like on the earth. So if you wanted to know where a particular person was at a certain point in time or whatever, like those latitude and longitude coordinates correspond to a specific spot on the earth. So we could plot those in any mapping software, like we could copy and paste this into Google Maps right now, and it would drop a pin in Google Maps, for instance, and say, okay, that's where latitude 25.984685, longitude minus 80.375979 is here.
And is that what you use to do your analysis, just those latitude and longitude?
No, I use other information on this sheet.
So you talked about the IMSI, IMEI, and so I'm going to go scroll over, and just if you could explain. So the next column is, so we said roaming group, I think model and make would be the next columns that for you to explain.
Yeah, so the roaming group, it's T-Mobile records, the phone that records apply to, you can see the model and make. It's an Apple phone, it's an iPhone 10. We'll skip to column. You can see in column K, it will say what type of record this is for. So data, which would be whatever, some sort of internet connection, whether you're using email or social media, or we'll say voice and data. Voice is obviously if you're making like a voice call.
Okay, so going down to row 91, is that an example of the voice and data?
Yes.
Okay. Make it a little bit bigger. Zoom in so it's easier to see for the ladies and gentlemen on the jury. Okay, continuing up at the top again so that you can explain the columns. Which specific column are you looking at when you are analyzing these records and the data in that?
So usually one of the most important ones is the time and the date. That's column F, because often when you're doing a case, and in this specific case I was asked, are the records consistent with certain things that the detective said?